the University of Houston Law Center, the Global Law and Policy for the Americas, also of ASIL academic partner, the University of Houston Law Center, the Association of American Law Schools International Human Rights Section, the ASIL Southeast Interest Group, the ASIL International Criminal Law Interest Group, the ASIL International Courts and Tribunals Interest Group, the ASIL International Law and Domestic Courts Interest Group, and the ASIL Transitional Justice and the Rule of Law Interest Group. Please allow me to introduce the other panelists and myself. Wolfgang Kalleck is the founder and general secretary of the European Center for Constitutional and Human Rights. He is currently scholar in residence at the Sorensen Center for International Peace and Justice at the City University of New York School of Law. He is the author of numerous books, including Double Standards, The West and International Criminal Law, as well as Law versus Power. He is also the recipient of multiple awards, including the M. Sharif Baswini Justice Award for the Forum for International Criminal and Humanitarian Law. Balkis Jarrah is interim director of the International Justice Program at Human Rights Watch, where she focuses on the Middle East and North Africa region. She also leads the organization's research and advocacy on universal jurisdiction and tools to enhance prospects for criminal accountability for serious crimes, including through fact-finding and investigative mechanisms. She oversaw the organization's research on the use of universal jurisdiction laws in Germany and Sweden to address abuses in Syria. And more recently, she is leading Human Rights Watch's accountability work on Ukraine. My name is Zachary Kaufman. I am Associate Professor of Law and Political Science and co-director of the Criminal Justice Institute at the University of Houston Law Center. I teach and write in the fields of criminal law, international law, and transitional justice. I've served in 3 international criminal tribunals at the UN International Criminal Tribunals for Rwanda and for the former Yugoslavia, and as the first American to serve at the International Criminal Court. I've also served in all 3 branches of the US government, including at the Supreme Court, the Senate Foreign Relations Committee, and the Departments of State and Justice. We're here today to discuss universal jurisdiction. First, I'll provide background on the concept of universal jurisdiction. Then Balkis and Wolfgang will discuss a case study. Afterwards, the 3 of us will discuss the future of universal jurisdiction in international justice. And then finally, I'll moderate Q&A with the audience. For those who are less familiar with the term, let me provide a brief overview of universal jurisdiction. Universal jurisdiction is the doctrine that some offenses, such as genocide, war crimes, crimes against humanity, torture, piracy, and slavery, are so heinous that they can be prosecuted by any country's domestic judicial system, even if the offenses were not committed on that country's territory by one of its nationals or against one of its nationals. This doctrine is based on the idea that perpetrators of such egregious offenses are enemies of all mankind, and so any country should be able to hold them accountable. Universal jurisdiction can take a variety of forms depending on a country's approach, such as which crimes the country considers to qualify for universal jurisdiction and what procedures are required to implement universal jurisdiction. Universal jurisdiction has already been used in several situations. For example, the UK considered extraditing Augusto Pinochet to Spain. Spain's prosecution of suspected atrocity perpetrators from Guatemala, El Salvador, and Argentina. Belgium's prosecution of individuals accused of participating in the 1994 genocide against the Tutsi in Rwanda, and Israel's prosecution of Adolf Eichmann. In 2021 alone, according to the Universal Jurisdiction Annual Review researched by Trial International, 125 international crimes were brought under universal jurisdiction, including 34 charges for war crimes, 66 for crimes against humanity, and 25 for genocide. These charges involved 22 countries of commission and 16 countries of prosecution. For example, stemming from the 1994 genocide against the Tutsi in Rwanda alone, charges are currently pending against a total of 19 suspects in Belgium, France, and the United Kingdom. It's also important to clarify situations in which pure universal jurisdiction is not the driving force. For example, although some claim that the International Criminal Court, the world's first permanent international criminal tribunal, is an example of universal jurisdiction, in reality, it is not. During negotiations over the Rome Statute, the treaty underlying the ICC, some countries proposed that the ICC include universal jurisdiction. However, a plenary vote rejected the idea. Rather, while it is true that the UN Security Council could refer any situation to the ICC's own territorial jurisdiction is limited to violations that are either committed by a national of a member state of the Rome Statute or on the territory of a member state. The concept of universal jurisdiction is controversial. On the one hand, universal jurisdiction can be and has on occasion been a powerful tool for addressing international crimes. Indeed, universal jurisdiction may be the only hope for accountability in some contexts. Alternative means of pursuing justice, such as prosecution by an international court or a domestic court where the crime occurred or the crime was perpetrated by or against its citizens, may be unavailable or too constrained. On the other hand, critics of universal jurisdiction raise several concerns, including first, that general principles of sovereignty typically dictate that domestic courts must have a closer nexus to the crime or its victims or suspects. That is, domestic courts typically have limited jurisdiction so as not to violate the sovereign equality of other countries or to interfere in their domestic affairs, as enshrined in the UN Charter. Second, universal jurisdiction trials may be held far away from where the crimes were committed and often many years later. Third, some countries would prefer suspects to be returned than to be prosecuted abroad. For example, Rwanda has requested that certain suspected perpetrators of the 1994 genocide who have been found abroad be extradited back to Rwanda. That request has sometimes been denied on the grounds that the custodian state believes that the suspect would not receive a fair trial in Rwanda. Fourth, there is some concern that universal jurisdiction will be or could be used for political purposes. So with that brief overview of universal jurisdiction in mind, let's proceed to discussing a case study in Germany relating to atrocity crimes in Syria. Our two other panelists, Balkis and Wolfgang, will discuss the case. And Balkis, please, if you will, go first. Thank you.
Thank you so much, Zach. I really appreciate the invitation to this panel, and it's an honor to be here with you, Wolfgang. I'm going to be sharing a PowerPoint presentation just to guide my presentation. So let's see if this is going to work. Zach, can you see my screen all right? Perfect. So we are going to talk about universal jurisdiction case study. And I'm first going to tell you what the case is about in very brief terms. For those of you who've been following the situation in Syria, you will know that tens of thousands of people have been detained or disappeared in Syria since 2011. The vast majority by government forces using an extensive network of detention facilities throughout the country. And thousands have died in Syrian government custody from torture or other horrific detention conditions. So the two accused in this case were Anwar R. and Ayad A., a former intelligence officer and a lower-ranking subordinate of one of the country's four main intelligence agencies that ran these notorious detention facilities. And Anwar R. was the most senior former Syrian government official to be put on trial in Europe. And he was convicted earlier this year for overseeing the torture of detainees between 2011 and 12 in a facility in Damascus. And Ayad A was also convicted of detaining protesters in 2011 and delivering them to that detention facility where they were later tortured. So that's just a few words about the case. But I want to explain to all of you Human Rights Watch's role and coverage of this trial. And then I want to focus on the views of Syrian survivors that we spoke to during the course of the proceeding. And finally, I want to point to some lessons learned that stood out to us and others during the course of the trial. So Human Rights Watch's role. Human Rights Watch, as Zach mentioned in his introduction, did a deep dive into German and Swedish efforts to tackle crimes in Syria at a very early stage and produced an in-depth report in 2017. I'll share the link later, on the work of war crimes units there. And we can talk about what exactly these war crimes units are, which included recommendations that were aimed at more and better universal jurisdiction cases. Why did we pick Germany and Sweden? Well, for a number of reasons, but chief among them is that these two countries had the highest number of Syrian asylum applications in all of Europe. And so it wasn't really a coincidence that the judicial authorities in these countries were the most active at the time. So drawing on interviews with police and prosecutors and Syrian refugees living in these countries, our research really highlighted the challenges that German and Swedish authorities faced in taking up these universal jurisdiction cases, as well as the experience of refugees and asylum seekers in interacting with the authorities in pursuing justice. Now, fast forward a few years later, we started to see an increase in the number of cases across Europe related to Syria. And this gave us an opportunity to draw lessons learned from concrete cases. And that moment coincided with the start of the trial in Koblenz, Germany. And working with lawyers from a law firm called Clifford Chance, we monitored the trial for nearly 2 years. And we hired an illustrator, a Syrian refugee in Germany, to capture the scene inside the courtroom. And Clifford Chance attended every single court hearing and produced over 1,500 pages of detailed trial reports, documenting some of the procedural and substantive issues that came up in the trial. And we hope to make those public in the near future. In addition to monitoring the trial, we also conducted interviews with survivors, journalists, lawyers, and others to learn about their experience engaging with justice efforts related to Syria and what significance the Koblenz trial had within those overall efforts. Now, the goal of our work around the Koblenz trial was essentially to popularize, to contextualize, and to personalize the struggle for justice for crimes in Syria. This is Amer. He's a Syrian journalist and filmmaker. Amer was one of the witnesses at the Koblenz trial, and in his testimony in April 2020, he talked to us about his experience of being arrested and tortured in Branch 251, the detention facility that I mentioned was the focal point of this trial. And he told us that when he first saw a picture of one of the defendants in the trial, things became very real for him and that he felt like a semblance of justice could be achieved. Now, survivors also told us that the case in Koblenz was significant, not only because of the high rank of one of the suspects, but also because it addressed the type of brutal criminality that was really emblematic of the conflict in Syria. So the trial wasn't speaking just to the guilt of the two suspects, but also lay bare the workings of the system that they were a part of. And so in that way, the trial in Koblenz was significant for Syrians, not only for Syrians who were directly affected by the concrete charges in the case, but also for others. We spoke to Munir El-Qadri, a Syrian artist and survivor, torture survivor. And as I mentioned before, Munir traveled to Koblenz for Human Rights Watch to draw some sketches from inside the courtroom. You see him doing that here. And when we asked him what the trial meant to him, he told us that the court is not going to overthrow the Assad regime, but it drops down the mask of the regime, and it really exposes it in front of the international community. And I thought that was quite poignant. Now, before diving into some of the lessons learned, I just want to say at the outset that it's important to acknowledge that the German authorities should be really commended for a very well-run universal jurisdiction trial. The judges in the case really showed their willingness to adapt to the unique nature of the trial, and they were flexible when it came to the hearing of witnesses. And according to our observation, they really went out of their way to make them feel seen and safe. And of course, they managed this trial in the middle of a global pandemic. The trial began in April 2020. So at the same time, some issues did stand out to us and others where justice efforts in Germany could be improved in other cases. And I want to highlight 3 issues: witness protection, translation or interpretation, and documentation. Since a lot of evidence in serious crimes cases like the one in Koblenz are testimonial, protecting these individuals from intimidation, making them feel comfortable and secure is really of crucial importance. And from our observation, several witnesses in Koblenz said that they feared for their own safety or the safety of their loved ones who were still in Syria or elsewhere. You see some of the quotes that came out of our trial reports. Some witnesses even canceled their appearance in court out of fear of retaliation. And in these cases, rather than summoning the witnesses, which the judges could do, they chose instead to bring in the police investigators that interviewed them previously to testify in their place. But of course, this had consequences for the weight that the judges attached to these testimonies. But overall, though this was an issue, the authorities were sensitive to these concerns and did put in protective measures when necessary during the trial. Another issue that we identified related to the lack of Arabic interpretation or translation of the proceedings, which impacted, unfortunately, its overall accessibility. The trial took place entirely in German. Non-German speakers were dependent on those who could be in the courtroom physically and who spoke German. And so that gap in interpretation was eventually filled by NGOs, journalists, and others. ECCHR, as Wolfgang can speak to, monitored the trial and produced daily trial reports. The trial was also covered by a podcast called Branch 251. But despite this, the lack of interpretation created a space for inaccurate information about the proceeding or what was being discussed in the trial to spread among the Syrian community. And attempts to access Arabic interpretation inside the courtroom for visitors in the public gallery in Koblenz failed, essentially. It was only through the intervention of 2 Arabic-speaking journalists that the court was eventually compelled to provide interpretation, but only to pre-accredited journalists through a decision of the German Constitutional Court. Now, providing Arabic translation to visitors in the public gallery would have been very easy for the court to do. They could have done one of 2 things. One, they could have provided for the interpretation over loudspeakers that were in the courtroom. And in fact, they did that on the days of the verdicts against the 2 defendants, or they could have allowed visitors access to the headsets that were in the courtroom and were being used by the formal parties to the trial, but were rarely used. And so it was very frustrating for individuals in the public gallery to see these headsets just sitting there. Amina Sawan, a Syrian activist, told us that she felt excluded from the trial as a result. She said that she thought that the trial was meant to be for Syrians, but not providing Arabic interpretation meant essentially excluding affected individuals. And she told us that the lack of translation made her feel that this justice process was rather formal than genuine.
There a huge barrier when it.
Munir, who I mentioned earlier, had a similar experience. He can speak actually German and understand German, and he traveled to several hearings in Koblenz, but it was difficult for him to follow the proceedings. And he told us that it really felt strange for him to be in the courtroom in a trial about Syrian state torture without fully grasping what was going on, at the same time as trying to capture some of the emotions and gestures of the trial participants in his court illustrations. Not only was it difficult and sometimes impossible for Arabic speakers to follow what was going on inside the courtroom, but the lack of an official court record is going to also make it difficult for future generations to engage with what occurred during this trial. There are no official transcripts and no audio or video recording exists. German law doesn't provide for the possibility of a written transcript, but what German law does provide for is an audio recording of trials of outstanding contemporary historical significance for Germany. Now, Human Rights Watch joined a motion that was spearheaded by ECCHR in July 2021 to obtain an audio recording for just the closing arguments of the trial after a first attempt was rejected, citing witness protection concerns, but the court unfortunately rejected the second attempt and deemed the case of not to be of significant historic importance for Germany, unfortunately. Now, despite all of these challenges, it's through the voices of those most affected, and I've referenced some of them, that many aim to make the meaning of this trial and its importance accessible beyond the courtroom. So it was an important symbol of justice, but it also served as a way to point to what has yet to be done to address the immensity of the crimes that have taken place in Syria over the last decade. And we hope that the information that came out of this trial can be used in other prosecutions, universal jurisdiction cases in Germany or beyond. So let me stop there and turn it back to you, Zach.
Thank you so much, Balkis. Wolfgang, you're up.
Sure. Thank you very much. And hello, everybody. I'd rather like to talk about the Syria complex than only the case in Koblenz. And you will see after I have talked why I'm doing that. Let's have a look into which factors led to finally to the Koblenz judgment from January. I would identify 4 factors: a strong, robust legislative framework. Second, a professional team of prosecutors and investigators. Third, political will. And fourth, civil society actors. So in detail, as you know, as you might know, the German Code Against International Crimes provides in its Article 1 more or less pure principle of universal jurisdiction, which leaves a lot of discretion to the prosecutor to not jump into investigations and prosecutions. And I will come back to that. But that is, in a way, outstanding legislation. Unfortunately, many European countries lack this, especially Spain, Belgium, who spearheaded universal jurisdiction in the early 2000s, don't have such a legislation. So it's very clear that we need, in order to make it more effective, we need more or less European-wide strong legislation, which is now lacking, and we hope that the Syrian cases will lead to law reform in that regard. The German law also allows investigations, but not trials in absentia, which is very important, because we are not only talking about those perpetrators who happen to be arrested in Germany because they're present. We are also talking about absent perpetrators, like the head of the Air Force Secret Service, Jamil Hassan, against whom an arrest warrant from Germany is pending. And Germany has other arrest warrants not publicized. But so there is also the intention to go after higher responsibles who are not currently in Germany, but who might happen to travel to countries with which Germany has legal cooperation. The second, professional prosecutors, investigators, that's true. They have special units, and this special unit, and that is worth to mention, are investigating since 2011 into the Syrian situation. So it's a huge, they call it structural investigation. That's an investigation into the situation where no individuals are particularly targeted. And in the context of this long investigation, they also analyzed the CISA files very extensively with a huge forensic team from the University of Cologne. But one has to say, and that is, I can perfectly connect to what Balkis was saying, and there are a lot of shortcomings. And that brings me also to the role of civil society, of organizations like mine, ECCHR in Berlin. We are not considering us as deputy prosecutors who are applauding or, bystanding the prosecutor. As good as the work is, there were some severe shortcomings. One is that not only the prosecutors, but also parts of the public, parts of other NGOs are completely underestimating the efforts which you need to accompany witnesses and torture survivors over years in these kinds of trials. These people are seriously traumatized. They need not only legal representation, they also need psychological support. And many of our clients, and we have over 100 over the years, many of them dropped out because they couldn't stand the pressure. And that is something, and we had situation in the courtroom where it was also clear that with all goodwill on the side of the prosecutor and the judges, they didn't know how to handle this situation. So it's a question of legal education. It's a question of even more specialized prosecutors, judges, and public. The other shortcomings have partly been mentioned by Balkis, but I want to mention two very serious shortcomings, and that is at the end, in the judgment, the court came to the conclusion crimes against humanity, but they didn't include forced disappearances, which we consider as a major error of the whole judgment. And the second shortcoming was the lack of inclusion of sexualized violence in the first indictment. And so it was up to us, NGO and our legal team, ECCHR and our legal team in the court, to force the court to include facts of sexualized violence in the indictment and later in the judgment. But it shows that there is a lot of work for us as civil society NGO actors. But legislative framework, professional prosecutor, that are more or less technical prerequisites. What is also similar important is the political will, and that's what we are observing not only in the Syria cases, but beyond. If there is a political will of mainly Western European countries to prosecute, something can happen. In the Syria case, it's clear they wanted to overthrow Assad. It's within their political concept to go against Assad's Syria, and so the trials are not only possible, but they're heavily supported by our governments, and that is where we always say, thank you very much for your sorrowful investigation into the Syria case, but we want you to go beyond in order to not to continue with the application of double standards. But without political will, and that makes universal jurisdiction political, without the political will, I see no real future for real universal jurisdiction. Fourth, the role of civil society. It's very clear, Balkis mentioned that already. The exiled Syrian community is very strong, 800,000 refugees in Germany, many of them former oppositionals, and also they have become part of the German society, and they perfectly link with groups like us. Actually, the torture survivor played a crucial role in the trial, especially at the very end of the trial. If you have the chance to read and to see their final statements, which are on our website, you see very strong acclamations of how they evolved from lawless, humiliated individuals in Syria to very strong and powerful actors who took a stand inside and outside the courtroom. And that brings me to the impact of the trial. That is one extremely important impact. That a very large group of affected people, of victims, has through these trials the chance to overcome their trauma. And it's not only them, it's their families, and it's the part of the Syrian society who was and is in opposition to Assad. And from what we heard from our clients, but also from Syria itself, the trial was heavily observed. The Arabic media were there. We delivered also trial reports in an Arabic language. And so that was heavily digested and commented. Obviously, and that brings me to another point, we have to be modest. This is not absolute justice. It's a step in the right direction. And that was recognized by us and also by our clients, the torture survivors, who said it's not the kind of justice, because in Syria still political detainees are held illegally and tortured. But on the other hand, it's a kind of a breakthrough, because it was the first case of this kind. And it makes it more difficult for Assad, because not only one perpetrator was convicted, but it was said that the whole apparatus carried out crimes against humanity. Ways forward, it's important to know that more trials are coming in Germany. The first one started already in February in Frankfurt, but we and others filed also complaints in Austria and France, in Sweden and Norway. And we hope that the breakthrough in Germany encouraged prosecutors and judges elsewhere. And also, last but not least, the German prosecutors, the federal prosecutor, explicitly said, we are willing to build up a stock of knowledge, including the forensic analysis of the Caesar files, which then can be used by other prosecutors in Europe. And so we are hoping that this gives the Koblenz case, the Syria complex in Germany, in a way inspires others to follow, not only on Syria, but beyond. Thank you very much.
Thank you so much, Wolfgang. So we're now going to discuss the future of universal jurisdiction and international justice. I'll provide some initial comments, and then we'll have Balkis and Wolfgang again. And afterwards, we'll move into Q&A. So Ukraine, of course, is on all of our minds, particularly whether and how crimes perpetrated by Russians in Ukraine may be prosecuted. And that's complicated, of course, by the fact that Russia is a nuclear superpower. Russia is not a party to the Rome Statute of the International Criminal Court, and Russia's domestic courts are presumably unwilling to hold Russian officials accountable while President Putin remains in power. The International Criminal Court has initiated an investigation, but for at least two reasons, the ICC shouldn't be viewed as the only mechanism that could or should be used to promote justice in this context. First, the ICC has limited capacity. Given how extensive the crimes are in Ukraine and how many Russian officials are likely involved, it's unrealistic to expect that the ICC could prosecute all of the accused. Second, the ICC has limited jurisdiction. Russian officials have been accused of perpetrating all four of the crimes under the ICC's subject matter jurisdiction: genocide, war crimes, crimes against humanity, and aggression. The first three crimes, genocide, war crimes, and crimes against humanity, can come under the ICC's jurisdiction in this context because although Ukraine is not a state party to the Rome Statute, it has twice accepted the court's jurisdiction. And in addition, 39 member states of the Rome Statute have referred the situation to the ICC. Although the ICC certainly does have jurisdiction over aggression, generally speaking, it wouldn't in this case because aggression is the one crime over which the ICC has jurisdiction, for which both states involved must be members of the ICC, and neither Ukraine nor Russia is. So if Russia's aggression is going to be investigated and prosecuted, it would need to be done by another judicial forum, such as an ad hoc tribunal. For both reasons, limited capacity and jurisdiction, universal jurisdiction may be a necessary supplement to the International Criminal Court for holding Russians accountable. Interestingly, we're already seeing that the US government is becoming more open-minded in its approach to international justice, and that's because of the two cases that we're talking about today, Syria and Ukraine. Most notably, after the Trump administration's extreme hostility to the ICC, both the executive and legislative branches, and both Democrats and Republicans, have more recently endorsed and embraced the possibility of the International Criminal Court prosecuting President Putin and other Russians. There are also indications that the US government was becoming more open to universal jurisdiction even before the Russia-Ukraine crisis. And this new trend relates to the other conflict we've already been talking about, Syria. The Syrian War Crimes Accountability Act was incorporated into the 2019 National Defense Authorization Act. Among other things, the law authorized the US Secretary of State to provide assistance to support investigations by third-party states of suspected atrocity perpetrators from Syria. As investigations are a necessary precursor to prosecutions, this law can be read to authorize US support for cases brought under universal jurisdiction, at least relating to Syria. In conclusion, universal jurisdiction may be a necessary supplement to alternative international justice mechanisms, and we're seeing that the US government's own posture appears to be changing. Balkis, would you like to go next?
Happy to, Zach. I'm glad that we are talking about Ukraine in the context of this discussion, because as some tuning in will know, unlike other situations like Syria, where most of the traditional options for accountability are currently blocked, whether through an international court like the International Criminal Court or at the national level, the conflict in Ukraine has put the entire international justice machinery into action in a very unprecedented way. The response by governments, as you've noted, Zach, to engage a range of accountability tools so that serious crimes in Ukraine are documented and eventually prosecuted, is really quite exceptional and nothing like anything I've seen during my time at Human Rights Watch covering these issues. You mentioned a number of the judicial actors in this space, but obviously there are a number of judicial authorities in a range of countries across Europe and beyond who have announced that they will be opening their own universal jurisdiction investigations with a view to prosecution. And they are part of a plethora of other accountability initiatives. So the justice landscape is at the same time very crowded and extremely dynamic, with fresh developments and new actors entering the scene every day. So while this overall picture presents a number of opportunities, it also presents a set of unique challenges. And when we think about the universal jurisdiction efforts in particular, but also other accountability initiatives, I think the question on everybody's minds is in this very congested space, how are all of these efforts going to be marshaled to maximize their success? So in other words, how are they going to be coordinating with each other? How are all the different judicial authorities in the various jurisdictions in Europe going to be cooperating with the International Criminal Court? How are they going to be cooperating with the Ukrainian judicial authorities, which, again, unlike Syria, are extremely involved in addressing ongoing abuses in Ukraine? So is there an overarching strategy? And I think one of the important lessons that I think we can take away from the Koblenz trial is that it shows the power of cooperation among authorities in Europe. So in that case, the arrests in the case were the result of a joint operation between German and French police. German authorities also reported interviewing witnesses in a number of other jurisdictions, including Norway, France, and Turkey. And the Germans and the French used a mechanism called the Joint Investigative Team that really facilitated that cooperation. And they and other judicial authorities across Europe are also using a forum called the Genocide Network that brings together all the war crimes police and prosecutors in Europe and beyond to share information and to also really draw some lessons from the different investigations and prosecutions that they're working on. So I think those kinds of mechanisms are going to be key in the Ukraine context. And in fact, we already see, at least there is a joint investigative team already in place that includes the International Criminal Court. But we can maybe talk more about that. I'll just turn it over back to you, Zach, to give Wolfgang the chance to chime in.
Thank you very much, Balkis. Wolfgang?
Yeah, thank you very much. So at least approaching the end of the session, we have a little bit of controversy because I don't agree with both of you. Again, we're not deputy prosecutors, and it's not our role to applaud our governments and our courts. We have a particular role in this game. And so, Zach, I don't at all agree with you that the UK and the US finally embraced international criminal justice. No, they are instrumentalizing international criminal justice when it's in accordance with their interest. I mean, both countries, we're not talking about the Chinas and Russias. They did never embrace any kind of, justice, even if it was in their interest. But the UK and the US did their part, that this kind of system, the architecture, developed after the Second World War. But in the last 15 years, they did 20 years, they did a lot to erode this system by, their selective approach, opposing any kind of accountability for war crimes in Iraq. And that goes for both countries. There was no accountability even in the UK for the massive torture in Iraq. So I think that has to be much more outspoken by us. There is a shared interest and there is an overlap of interest between us and parts of our governments and parts of our judicial system. But we have also to spell out when and what when we don't agree. And so, Balkis, when it comes to Ukraine, it's absolutely right when you said what happened there in the last 2.5 months was unprecedented and it's exceptional. But this is exactly the way to erode in the international criminal justice more than it has been eroded in the last 20 years, because this established no kind of legitimation by global Southern actors. Everybody points to the Iraq war. Everybody points to the fact that the UK and the US stood in the way of a real robust legal framework against the war of aggression. So, you know, we are also exploring the Ukraine situation. May Putin and his generals at some point be held accountable, but with the existing mechanisms and not creating any new, only him targeting Russia tribunals. If the last 3 months lead to the establishment of a standard that all war crimes in the world have to be investigated and prosecuted, wonderful. If the debates around the tribunal against aggression leads to a tribunal against all wars of aggression, wonderful. But if it's only targeting Russia, I think that's the wrong way, and that will harm international criminal justice and real universal jurisdiction in the long run.
Zach, could I respond to?
Please do, Balkis.
I agree with everything that you've said, Wolfgang. I think what the Ukraine situation is surfacing is a real double standards and selectivity in the application of international justice. And I think, as I said earlier, the situation for that reason presents a great deal of risks, as you've rightly pointed out, but there could be also opportunities here to capitalize on. And I think that it is incumbent on us as civil society to try to, make the most of this moment, to build out and to strengthen the international justice architecture as a whole, and to ensure that all this political will on accountability is indeed used for all the other many, unfortunately, situations where ongoing crimes have become the norm, and where impunity is also the norm. So I'll give you some thoughts, and I would be interested in your responses, Wolfgang or Zach. But for example, obviously the International Criminal Court is going to be an anchor of some sort in addressing the situation in Ukraine, and it is receiving unprecedented support from its member states and beyond. And the question is this a moment for universality? In other words, can we be pressing countries who are expressing their commitment to the principle of international justice and accountability to translate that into concrete action by becoming a member of the International Criminal Court? Now, because we're talking about universal jurisdiction in this panel, I mentioned that a number of judicial authorities across Europe have opened, or at least announced, that they've opened criminal investigations into the situation in Ukraine. A number of these countries don't have the legislation or the institutional infrastructure that we have been talking about, Wolfgang, in Germany. Germany is in many ways the Rolls-Royce of universal jurisdiction. And so is there, again, an opportunity here to build that infrastructure in more countries in Europe and beyond, again, capitalizing on the attention and the political will that we see on Ukraine? But just some food for thought.
I agree with Balki's comments too, and of course my colleague Wolfgang as well. There's evident inconsistency, hypocrisy, duplicity in the approach that some states, including the United States, take with respect to international justice. That is blatantly obvious. At the same time, I think, as I think Balkis is reminding us here, it's important to recognize progress where progress is made. And given that some of the opposition to the ICC and universal jurisdiction are about concerns over politicization and fairness, perhaps the demonstration in the context of both Syria and Ukraine could alleviate some of the opposition from non-member states of the ICC and opponents of universal jurisdiction. At least that would be, I think, part of the hope moving forward. I'll turn to Wolfgang for some additional comments, and then we'll move to the Q&A in our final minutes.
Yeah, thank you very much for both of your remarks and the clarification. And actually, I already read some of the questions, and so I appreciate Donna's remark that we have to address the elephant in the room. But Balkis, to clarify this from our point, we, even before the Koblenz trial, we said very clearly that we spent like 10 years as an NGO, and it was the biggest single project at our NGO to go into the Syria cases, because exactly of the reason you just mentioned. We think it gives us a chance to establish a standard which then has to be universalized, but which is not universal. And we wrote that, and you asked before about reading recommendation. We wrote that in an article by my colleague Patrick Croker and mine in the Journal of International Criminal Justice 2018 on the Syria cases, and we said, breathing new life into universal jurisdiction in Europe. That was our claim and that was our idea. But that requires also, when we sit down with the prosecutors, to say, thank you very much what you did for the Syria cases, but now apply the same standards also in other situations which are more uncomfortable for our governments and for Western actors. And that's not happening. I mean, we filed cases against corporate actors who delivered surveillance technology from Germany to Syria, even until 2012. And the case was put on hold, but so quick that you couldn't even watch it. So I think, there is a need to spell that out, what it means, universal standards. And that means that we should not just embrace our governments, but also make it very clear what it needs to really establish universal standards. And I'm very doubtful that they really got it, because the legislative framework, not only of the war against aggression, but also of international humanitarian law, is weak, as we all know. And we all know that exactly the states who are now spearheading, the efforts, the legal efforts against Russia, are those who have stood in the way for a stronger legal framework. Sorry.
Thank you. We only have about 6 minutes left, tragically, and we have a ton of questions and comments. So let me just try to get to a few of them at least. There are a few questions about alternatives to criminal prosecutions or criminal jurisdiction. So the question that I'd like to pose to Wolfgang and Balkis is, what do you think of the role of non-criminal actions and sanctions as an alternative to criminal prosecutions for Ukraine and Syria? Balkis, do you mind going first, please?
Sure. Maybe I'll just mention one possible avenue, and that's at the International Court of Justice. that deals with state responsibility rather than individual criminal responsibility, what we've been discussing today in the context of universal jurisdiction. And again, reflecting on the Syria situation in a context where, as I said earlier, most of the traditional avenues for any kind of accountability are blocked. It's really forced activists, lawyers, diplomats, and others who are committed to justice to think outside of the box. And that's manifested itself in a number of initiatives, one of which relates to the International Court of Justice, where one state is, it's a very early stages yet, but using the Convention Against Torture basically to hold Syria responsible for all the abuses that have occurred over the last 10 years. And there is value in that, again, because if successful, will provide some kind of a official record with some international imprimatur, and it could be used down the line in criminal prosecutions as well. But the International Court of Justice is not the only avenue. I'll turn it over to Wolfgang.
Yeah, thank you very much. I would say the blueprint for our work, ECCHR's work, is actually the work in Chile and in Argentina, where is very strong human rights movement used a complementary approach. And complementary means they exhausted all domestic legal remedies. They used the international American mechanisms. They used soft law mechanisms. And finally, they also went to Europe and filed universal jurisdiction cases in order that triggers something in their countries, which then happened especially in Argentina, with now hundreds of convictions. But that was not the only thing. It was a very interdisciplinary approach, because it was civil society actors demonstrating on the streets. It's artists who took up the issues, and that is something which is needed in all this work. So what I also very much regret in this current debate on Ukraine is the way how lawyers put themselves in the forefront, how lawyers sell their work as the solution for the war, which it isn't. We have to first establish peace, and then we see and we have to make it clear that criminal justice needs its time. Accountability mechanism needs its time. We have to start now, but we will see the results much later. And so other initiatives like artists, filmmakers, writers, journalists, that investigators of all kinds play a very, very big role. But I think what is important about justice is once the justice machinery works, it provides us with a factual basis. And I think that's important as a reference for future discussion. These facts have happened, and they can be framed as crimes against humanity. I think that's incredibly important. Just two remarks to two more questions. One, Hugo, you asked about immunity. Immunity played no big role in the German trials. There was nobody invoked it. And second, to clarify misunderstanding, I didn't say that China doesn't care about international criminal justice, but China has no elaborated position on international criminal justice and the ICC. They don't enter the stage and say we would recommend to prosecute these crimes or that crimes. So they are more or less absent. That's what I meant.
Thank you very much, Wolfgang. We're unfortunately about a minute away from ending. As a final question, let me just ask one of the questions that was in the list, which is: are there certain resources that you can recommend to track the further development of universal jurisdiction. Balkis, can we start with you, and then we'll move to Wolfgang briefly, and then we'll wrap up. Balkis, please.
I mean, Zach, you mentioned one of the resources in your introduction, and that's a Bible in many ways of all the developments over the year, universal jurisdiction developments. Publication, I think you dropped in the chat, Trial International. It's a collaboration with Trial International and some other organizations, including ECCHR. So I would really recommend that. And I will drop in the report that I mentioned about Sweden and Germany from Human Rights Watch there as well.
Thank you, Balkis. Wolfgang?
That's the report. The link is included. And I heard also from the organizers of ASI that there is a possibility that we, the speakers, recommend other reads after this chat. And so I will deliver some recommendations to you on that way.
Thank you. And I see the comment in the chat that we need a part 2 or even a series of webinars on this topic. I agree that this is an underexplored aspect of international justice, universal jurisdiction is. And I look forward to engaging further with Wolfgang and Balkis and applaud them on all of their excellent work. Thank you so much to Wolfgang Kalik and Balkis Jara for participating today. Thank you again to ASIL for hosting us, and to all of our co-sponsors for supporting this event, and to all of you. I apologize that we didn't get to all of the questions, but thank you so much for your engagement and interest, and we look forward to seeing you in the future. Thank you.